Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Hi everyone, hope you're well. I've got 3 different cases that I'm going to chat to you about this month. We're actually going to be revisiting a couple of topics that I've covered before: unfair prejudice claims and the National Security and Investment Act, which both seem to be rapidly becoming friends of the podcast. But first up, I'm going to talk to you about a decision in the High Court where the court considered provisions in a company's Articles of Association relating to the forfeiture of a shareholder's shares. And although the provisions in the articles purported to allow forfeiture for the non-payment of any amount owed by a shareholder to the company, the court found that in fact the provisions were restricted just to the non-payment of an unpaid amount due on a shareholder's shares. So what do I mean when I'm talking about forfeiture of a shareholder's shares? Let's think about that for a moment. So forfeiture refers to the process under which shares can be, if you like, taken off a shareholder if the shareholder in some way fails to meet their obligations to the company. Now, there's no statutory process permitting forfeiture of shares, so a company can only do that if it has a power of forfeiture set out in its Articles of Association, its own internal regulations. So typically, a company's articles permit shares to be forfeited where they've been issued nil or partly paid, because in those circumstances, the shareholder has an obligation to pay the unpaid amount due on those shares if the company issues a call for that unpaid amount. And then, if the shareholder fails to comply with that call, the articles will usually go on to enable the company to forfeit or, if you like, extinguish the shareholder's shares. Now, the model articles for private companies limited by shares assume that all a company's shares will be issued fully paid. So they don't have any forfeiture provisions in them. But the model articles for public companies anticipate that that kind of a company might want to issue nil or partly paid shares. So those sort of default articles do contain provisions that set out when a company might call for the unpaid amount due on those shares, and then what happens when a shareholder fails to comply with that call, which, as I say, could ultimately lead to the shares being forfeited. So, in this recent case, a former director held 57 fully paid shares in a company. The former director issued a winding up petition against the company. That petition was dismissed, and the former director was ordered to pay the company's costs, which was just over £162,000. The company had adopted the model articles for private companies limited by shares, but with certain amendments to those sort of standard default articles. Now, in particular, they'd added provisions relating to liens, calls, and forfeiture, and those provisions seemed to have been drafted using the equivalent provisions from the model articles for public companies. So that was the basis that they'd used, whoever had drafted the articles, but then they'd made a few amendments. So those included changes to give the company a lien over every share in respect of all monies payable by a shareholder to the company. So not just a lien over partly paid shares for unpaid amounts due on those shares, which is the standard provisions. And then also an amendment to allow a call notice to be served in respect of any sum due to the company from a shareholder and not just an amount payable in respect of the shareholder's shares. And then, if that call notice remained outstanding, to forfeit the shareholder's shares. So, following the dismissal of the winding up petition, remember the former director who brought that winding up petition now owes the company £162,000 worth of costs. The company issued a call notice to the former director in respect of those outstanding costs. And when the former director didn't respond to that notice, the company then took steps to forfeit his shares in accordance with those provisions set out in its Articles of Association. But the former director said that both the call and the forfeiture of his shares were illegal, and he brought a claim in relation to that, and the court agreed with the former director. So, when looking at these provisions in the company's articles, the judge noted that they had been specifically and deliberately amended in an attempt to expand the meaning of call to include any sums outstanding from the shareholder to the company. But the judge went on to highlight various inconsistencies and ambiguities in the drafting of those particular provisions. So, for example, the words "in respect of shares which that member holds" had been removed from the provision relating to when a call notice could be issued, but they remained in the consequential provisions relating to forfeiture following such a call. Also, the articles didn't take into account the effect of extending the lien and call provisions, as the person drafting the articles had tried to do, on joint shareholders. So, as a result, they could end up becoming a guarantor of their co owners' liabilities if one of those joint shareholders has a liability to the company and the company then forfeits shares held by both those shareholders, joint shareholders, where one of them doesn't actually have a debt. So you've effectively made them a guarantor, which they might not have understood. And then finally, if the company was able to forfeit shares but wasn't required to account to the shareholder for any value of those shares in excess of the amount due to the company, then that could result in a windfall to the company and a penalty to the shareholder. So remember, in this case, our director owns 57, our former director owns 57 shares and owes £162,000 to the company. Well, if those 57 shares were worth significantly more than £162,000, arguably the company has a windfall because it could sell those shares on to somebody else, but the director has been penalised. So, because of all those issues, the judge said that the articles had to be read as impliedly limiting calls just to unpaid capital on specified shares. As the only point of serving a call notice was to set up the possibility of forfeiture, the judge said it was clear that the word call was limited to sums payable in respect of unpaid share capital. So, as I say, provisions relating to liens, calls, forfeiture are usually limited to nil or partly paid shares, but in this case, the relevant shares were actually fully paid and no sum was due from the shareholder to the company in respect of those shares. The shareholder did owe money to the company, but it was completely unconnected with their shareholding. So it is quite tempting, I think, to try and extend those kind of provisions that you see in articles of association to any shareholder debts. But obviously, this case is a little bit of a warning notice about the dangers of doing that. And if your company has included similar provisions in its articles of association, then you should consider updating them either to remove any inconsistencies or ambiguities, the issues that ultimately led to the failure in this case, or else you just need to recognise that those provisions will only be useful in dealing with unpaid share capital. Okay, so the next case involved the High Court dismissing an application for judicial review of a final order made by the Secretary of State under the National Security and Investment Act 2021. I'm going to call that the NSI Act. So the final order required the claimant to divest its entire shareholding in a company that it had acquired 2 years previously. And the case, it's interesting, I think, because it's the first judicial review challenge under the NSI Act to reach the High Court, and it confirms the very wide discretionary powers given to the Secretary of State under that Act to prevent, remedy, or mitigate any perceived risk to national security. Now, as I say, I've talked about the NSI Act before on the podcast, but as a reminder, it allows the government to scrutinise and intervene in certain acquisitions and investments that could potentially harm the UK's national security. And the Investment Security Unit, the ISU, that's a unit within the Cabinet Office, is responsible for operating the notification and screening regime under the NSI Act. So if you've got a transaction within scope of that regime, then it can be called in for assessment if the government reasonably suspects that it poses a risk to the UK's national security. In addition to those call-in powers, acquisitions or investments in one of 17 high-risk sectors have to be cleared by the ISU before completion. And if you don't get that clearance, then that acquisition will be void, and the acquirer, the buyer, could be subject to criminal or civil penalties. If there is a national security assessment, then following that, the Secretary of State can impose remedies that they reasonably consider to be necessary and proportionate to deal with the national security risk. And those include things like approving the transaction but subject to conditions. So that could be things like restricting access to sensitive sites or information, or the government could block a deal, or they could require an acquisition to be divested or unwound, as in this particular case. And then when the government makes a final order, it can choose, but it doesn't have to provide financial assistance. So the facts in this particular case date back to January 2021, when a buyer acquired the entire share capital in a target company. And the target's business involved bringing next generation broadband services to underserved rural UK communities. Now, at the time of the acquisition, the ultimate beneficial owners of the buyer were a group of Russian nationals who became subject to EU and UK sanctions following the Russian invasion of Ukraine. Shortly after the NSI Act came into force, which was in January 2022, concerns were raised by the government about possible national security risks to the UK telecoms infrastructure arising from the buyer's acquisition of this particular target. These risks included the potential for espionage, the ability to disrupt and sabotage the UK's broadband network, and access to company data that could then be used to potentially undermine national security. So, because of all those concerns, the ISU called in the acquisition for assessment. So, it carried out an in depth review, and despite the buyer's representations for less draconian measures, following that review, the Secretary of State made a final order requiring the buyer to divest itself of 100% of its shareholding in the target. And the buyer basically subsequently sold those shares at a loss. So the buyer then brought judicial review proceedings in January 2023, arguing that the government's final order infringed their human rights. They said it amounted to a disproportionate interference in the buyer's property rights, and that the buyer was entitled to compensation for the loss caused by the sale of the target shares. And then the buyer also argued that the decision was procedurally unfair, that there was insufficient disclosure of the alleged national security risks, and also that the buyer had insufficient opportunity to address the Secretary of State's concerns. So, in the High Court, the buyer's application for judicial review was refused. On the question of whether the divestment remedy was proportionate, the court noted that proportionality was part of the statutory test for making a final order under the NSI Act. And well, the court said, well, the Secretary of State could be assumed to have considered it. And the court found that the government had effectively balanced community interests with the rights of the buyer, and it deferred to the Secretary of State's opinion that national security could not be protected by less intrusive measures. As for compensation, well, the court found that the interests of national security had to prevail over the buyer's financial interests, and that awarding financial assistance was a discretionary power anyway and not obligatory. Then, in relation to sort of the second ambit of the buyer's claims, the procedural unfairness claims, the court was satisfied that the decision to make the final order was, in fact, based on a fair process. It found that the duty on the Secretary of State was to act in accordance with accepted principles of fairness, no more and no less than that. And provided that process was fair in the eyes of the court, then it was ultimately up to the Secretary of State to decide what procedure to follow. The NSA Act did not expressly impose a duty to consult, and the court considered that the buyer had, in fact, been given adequate opportunity to understand and to comment on the case against it. So, like I say, the NSI Act was drafted to give the government very wide discretion when assessing risk to national security and deciding on what it thinks is the appropriate remedy to manage those risks. So, it's probably pretty unsurprising that in the absence of very obvious procedural unfairness, then a court is just going to uphold the Secretary of State's decisions. But for the relatively small number of acquirers whose transactions are called in for review, I think this decision could cause a bit of frustration, really. It illustrates, I think, the limited scope within the current process for challenging the government's objections, not least because national security itself isn't actually defined in the NSI Act, and then the lack of opportunity to address the government's concerns when those concerns are not clearly articulated. Okay, finally, in our last case this month, the High Court struck out part of a shareholder's unfair prejudice petition on the basis that a failure to transfer shares between shareholders did not relate to conduct of the company's affairs. So, what do I mean by an unfair prejudice claim? Well, this is the main procedural route for a minority shareholder to petition the court when they believe that the company's affairs are being conducted in a manner that is unfairly prejudicial to their interests. Now, for the claim to be successful, the conduct complained of must relate to the company's affairs, it must relate to the shareholders' interests in their capacity as shareholders, and it must be prejudicial to the shareholder and unfair. If the court finds that a claim of unfair prejudice is made out, then it's got very wide powers and it can make any order that it thinks appropriate to put right the prejudice complained of. Now, in theory, that includes the very draconian remedy of ordering the company to be wound up. But in reality, the most common remedy requires the shares of the shareholder making the claim to be bought out at fair value by the other shareholder or shareholders. So, this recent case that I'm talking about involved a minority shareholder in an interior design company. And the company founder transferred 10% of his 100% shareholding to the minority shareholder. But she, the minority shareholder, alleged that they had agreed that the founder would gradually transfer further shares to her over a number of years if the company met certain financial targets. Now, according to the minority, that arrangement was itself then replaced with a new agreement under which she was immediately entitled to a 49% shareholding in the company. There were some references to the arrangements in email correspondence between the parties, but there were no formal agreements entered into in relation to this. Now, the founder denied that the arrangements alleged by the minority shareholder existed. To the extent that they were referred to in email correspondence, the founder said that it was always understood that this would be subject to legal advice and tax advice, and that actually, in the end, the discussions between them came to nothing. So the minority shareholder issued a petition in which she argued that the company's affairs had been conducted by the founder in a manner that was unfairly prejudicial to her interests. The founder then applied to strike out those sections of the petition relating to his failure to transfer shares to the minority on the basis that a transfer of shares, didn't amount to conduct of the company's affairs. And when it came to the court, the judge agreed with the founder. So the judge confirmed that the statutory requirements had to be dealt with on a step-by-step basis. And he said, firstly, you've got to ascertain whether the matter complained of qualified as either an act or omission by the company or conduct of the company's affairs. And only if that requirement was satisfied would the court then move on to consider unfair prejudice. And in this case, the minority shareholder's claims to receive additional shares by transfer from the founder were directed solely at the founder. There was no allegation that the company was required to do or not do anything. And the claims related to a purely personal arrangement between the founder and the minority, and they did not involve the conduct of the company's affairs. So the judge distinguished an earlier case, which, rather than a transfer of shares, as we had in this case, related to an allotment of and issue of new shares by the company. So that clearly did involve the company and the conduct of its affairs. But in this case, the judge struck out those parts of the minority's petition that were relating just to the transfer of shares by the founder. Now, it's interesting, and as I say, I've talked about unfair prejudice claims on the podcast before, but I think the use of unfair prejudice petitions is on the rise, and there have been significantly more petitions issued in the last few years than previously. I think perhaps given that a buyout order is the typical remedy for a successful petition, maybe some minority shareholders are using or trying to use an unfair prejudice claim as a strategic tool to engineer an exit. But I think, as this case shows, the court will exercise its discretion to strike out weak claims and is not going to allow that process to be used for nuisance petitions by aggrieved shareholders. So that's it for this week. I hope you find those cases useful, and I'll see you next time. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.